Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Nipasa, and I'm going to be with you for this session today. And it's going to be a short one today, shorter than usual. We'll keep it at half an hour. So, yes, before we head on with today's discussion and have our guest join us, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, friends, welcome to Immigration Talk Show. Don't forget to subscribe to us, hit that bell icon so that whenever we have discussions like these, you're notified, and also that you stay updated with the latest on immigration news. So, yes, today's discussion is going to be on got an H-1B RFE. What are the common reasons and best ways to respond? So, we are going to discuss this with none other than our guest for today, who is John Khosravi. He is the founder of the JQK Law Firm, president of the educational and media company Immigration Lawyers Toolbox, and also host of the Immigration Lawyers podcast and publisher of the Immigration Lawyers Toolbox magazine. So, as an immigration attorney, John and his team have really helped hundreds and so many out there, the clients, for over the last 12 years to fulfill their dream of living, working, and studying in the United States. So, yes, without further ado, please help me welcome him back to the show. Hi, John. How are you doing today?
Hi, Nico. Thank you so much for having me on. I'm doing good. How about yourself?
I'm doing good too, and
Wonderful.
it's always lovely to have you. So, yes, with the topic of discussion today, what can friends out there expect from this session?
Well, we're going to talk about the H-1B process, and there's going to be a focus on like RFEs, requests for evidence, when someone has an issue with the case or the government has an issue with the case and asking for more documentation. But just a heads up, the H-1B process is a lottery system for the most part. If you're going to work for a nonprofit organization or something like that, you don't need to join the lottery. But the lottery means that every year there's only a few amount of visas available, and you have to register first. Buy a ticket to the lottery, which is right now. It opened up a week ago, and it's open for another week. So employer during this 15-day period or so registers online with USCIS. They increase the fee to be able to register for it to $215. And then in a month or so, they'll release the results if you're chosen. And there's always a little bit nuances here that I'm just brushing over. But if you're chosen, then you can file the H-1B case, form I-129. The employer does it. The employer does everything essentially in these cases, and they pay for it as well. They're supposed to. And if you're submit the paperwork, then you might get a request for evidence saying there's issues. And we're going to discuss that, but I'm happy to discuss the general process of H-1B as well, especially because it is the filing season right now.
Yes, absolutely. So, friends, the filing season is on and it'll be on till the 24th of March, 12 noon Eastern Time. So, keep in mind and don't leave anything to the 24th. I think you should finish much before that. So, yeah.
Yeah, we have
John,
people calling us even now for H-1B filing, and it's just a lot of fast moving stuff you got to do to make sure it's something we can do.
yes, absolutely. And I think it's always best to have an attorney guide you. So why not contact attorney John Khosravi as well? His details will be scrolling on the screen very soon. And friends, you can also join us on this conversation by dialing this number 425 436 6335, and the access code is 988 888. So, John, coming back to our topic of discussion, I also prepared a couple of questions. So, if you could, tell us some of the most common reasons, USCIS issues a request for evidence or an RFE for H-1B petitions.
Sure. So, the H-1B process is for specialty occupations. And a lot of times the immigration department makes these terms up, and then the definitions keep changing every day. And every officer reviews it has their own definition of what a specialty occupation is, though it's somewhat listed. But that becomes a major problem when they say, okay, this work that they're doing is too general. It's not specialty occupation. Now, if you're doing H-1B as a lawyer, okay, lawyer, they know what it is. But if it's some sort of analyst, it gets kind of vague. So having a detailed description becomes really important. And then another one is just the educational background. Do they have, qualifying bachelor's degree? One issue that pops up for India, which is 95% of the H-1B visas probably, is the bachelor's degree there could be a 3-year bachelor. So sometimes we have to show that there's an additional year of education in addition to that, maybe a master's degree. as well as you could do a 3-in-1 rule. So if you have 3 years of experience in that area after graduating, you could use that as 1 year as well. So that degree background becomes really important. Sometimes you need to get expert letters for it and stuff. And then it really just about whether the job is too generic or it's not expressed right, or it's too entry level of the job. It doesn't. It's not really what the degree needs, or a job that requires a degree per se. So a lot of it is questioning the job itself, and whether it's a proper appropriate job. And then the other a lot of times is educational level. Then there's a million and one issues: a person's background, the little like typo kind of stuff, or for example, they say we have such and such work experience, but in the past, the foreign applicant had applied for a tourist visa, never listed any of that employment. So now in H-1B, they're saying I worked for 4 years for this company, but they're like, well, in your B2 tourist visa application, you listed that you were a homemaker. So how did you work for that company? You lied somewhere. Are you lying here or lying there? Which one is it? And these stuff, especially with the technology getting better, where they can access old databases of evidence and information, is becoming more and more of an issue in these kind of in just all cases, but including these ones.
Absolutely, and there's going to be more scrutiny, more, I mean, much more than ever before. So, including your social handles
Yeah.
being watched, from what I hear, right, John? What do
Yeah,
you
so
want
I
to
mean,
say
this
about
year is going to
that?
be a completely anything we talked about. These might be the easy problems we're saying. It might be a whole new set of problems happening because there's the Trump administration's here. It's the first cap season that they're going to be under control of. One thing they're adding, it's probably in 45 days going to be added to the new applications, is all the social media stuff in the U.S. as well. They used to ask you for, they've been asking you for if you're getting a visa through the embassy, they're adding to the U.S. But additional stuff and extreme vetting is coming back, and all sorts of different background stuff and delays. And so H-1B is a very controversial visa too, so that's going to be a problem. Staffing issues. So you could submit your H-1B case. It might take forever for them to even make a decision, or you might get approved. You go to the embassy interview, and they don't have any appointment times available, and they're backed up. They do an interview, but they can't approve you for a while. So everything is a unknown. Everything I pretty much all the experience I may have, it might not even matter for what's happening. It's everyone's making it up as they go along because everything's going to change. And so it's a fight day by day as this new situation, new regime is in charge of the H-1B process.
True that. Thank you so much, John, for that. And now, I have this other question. And if you could tell us, how employers and employees proactively reduce the chances of receiving an RFE, especially while filing the H-1B petition.
Sure. Whenever, depending on the job title, especially having really good job duties of what they're doing is going to be really
Mhm.
important. So again, if you're a lawyer or very unique jobs, that's like people expect there to be a degree for and stuff like that. But it's more open-ended. Marketing person, for example, really specifying how their degree relates to it and as much as possible. Having the educational credentials already looked at. Sometimes getting an educational evaluation beforehand, which costs extra money, which a lot of times employers don't want to do. But having that evaluation becomes really important to show that it's equivalent. Having all that paperwork ready. And another thing that employers run this operation, so they're really focused on the H-1B portion of it. But they don't, and the lawyers are really focused on that as well. But they might not spend as much time looking at the background of the applicant to see, okay, did you ever file for a green card before? Did you ever do other kinds of applications before? Because we might get the H-1B approved, but we don't know if your background's okay. You might have other issues. You might have been some part of some organization that the government doesn't like or doesn't want. Right now, it's a big controversy in America right now where a green card holder, too, not even a visa holder, a green card holder was showing sympathy to Hamas on college protests, and they want to take his green card away. So if you're on social media where you said I support Palestine, and then you say I support Hamas or Palestine in this effort, that could be used against you and get your visa denied. This has never been happened before. I mean, it happened, I don't know, during communist times with Russia, if you're a communist sympathizer. These are old rules from way back when. But any recently, maybe 30 years ago, there was one random one. It's very rare to use these laws, but they're being used. A law that's rarely, if ever, been used in the last 100 years is being used again. So not only is it just watching out for the H-1B stuff, that's a typical kind of thing here, but it's also just personal stuff.
Yes, so true. And that said, Mahmoud Khalil, an activist. So yes, it's happening, and there are problems arising where what we've seen situations like this have never risen before. So at least in the recent past. So Yeah, let's see. Let's go on to our next question. Also, John, if you can also tell us, are RFEs becoming more common due to policy changes, and how has the trend evolved in the recent years?
Well, they went up dramatically during the Trump administration. They had a policy of no deference. So, like, if you had H-1B approved and you're renewing it, they would start everything from scratch. The policy before was you got to approve before. We're not going to re-adjudicate the whole thing. Trump said everything, redo it from scratch. So that was a big hassle and delays. But then Biden administration went down. The expectation is going to go up. And there's been some changes. The Biden administration, before they left, they updated the policy where they said usually there has to be an employer-employee relationship. So if you own a company, it's almost very difficult to apply for your own H-1B because they'll say, "Oh, you're just trying to hire yourself. That's not the real H-1B." But they opened it up where you could be the majority owner of the company and still apply for an H-1B, but you have to show that you are, a real employee. You get fired and all that kind of stuff. And this is a new policy that has been tested. You could have got away with this sometimes before, but it hassle you. But as a formal policy, that was okayed as a new thing. But we'll see if this administration is going to get rid of it or just not really get into it or find problems with it. So that's like a big one that's probably going to happen a lot because a lot of people want to take advantage of this option. If they own a company, they want to file for their own H-1B. So that's something that's going to be happening. But again, they're going to be picking out whether there's a specialty occupation, going through the degrees, and just delays could be really problematic.
Right. And from what we hear, there could be more RFEs also. So we'll just have to see what could happen this year. And it's really early to say because there just has been the policy shift. I mean, a change in administration and a lot of new things coming up every day. So let's just wait and watch for now. And now let's take up Yuri's comments. He has a lot to say or ask. Let's find out. So Yuri is saying, I am in my sixth year of H-1B and my employer filed for an extension based on a pending perm. The RFE is asking for proof of 1 year pending labor certification. How do we prove this in a way that satisfies USCIS?
So it should relatively be easy. This is based on the AC-21 extension. These are the rules they made about 25 years ago, updates to give this flexibility. So the H-1B has a limitation on how many times you can renew. But if the employer starts a green card case, they file a perm, a labor certification, and the process going forward, then you get 1 year renewals until that process is done, which could take forever sometimes. You just keep renewing it every year. But if you have a labor certification filed or your I-140s pending, you kind of just have the receipt notice showing that it's been pending for a year. So usually you file that with the application as proof that that's happening. I got to see what unique issue may exist here, but usually it's pretty straightforward. This wouldn't be the issue that people have RFE unless they just forgot to put, or the government didn't read it. It's in there, your application, your extension, but the government didn't just notice. That might be the situation. But here has another question about whether he could stop working if he does a H-1B transfer. So H-1B transfer is if you're working for one H-1B company and you go to another one that wants to sponsor you, you could do that. The main thing is it has to be timely filed within the grace period, the 60-day grace period. And one thing about that grace period is discretionary, even though they usually approve it, but they made it where they could say, oh, there's no grace period. So it's kind of annoying. The safest thing to be is like working for the first one, immediately request a transfer, and then once it's approved, shift. But having said that, it's usually not necessary. They usually abide by the grace period that they give. But whether you can work, the rule is that as soon as the file gets to the government, you can start working. You kind of wait for you get the receipt notice. But if you get the H-1B transfer receipt notice, you're allowed to start working with the new employer. And so that's a pretty good situation there. I can hold you over. Now, if you have a perm pending, that creates all sorts of other issues where you could transfer the labor certificate to a new company. You probably can in this case because you have to have I-485 pending to be able to transfer I-485 pending for 6 months. Getting kind of technical here. I'm not sure if you'll be able to save your perm with the old employer if you move, but generally, yeah, if you just file it, upon filing, you can start working for a new employer.
Right. Thank you so much, for taking up Yuri's questions and comments, John. We
You
have
got it.
Kritika. Kritika's, yeah, sure. Tell
Same
me.
kind of question. I'm sorry, but it's the same question where you can start working. If it's a properly filed H-1B, you could file. You could continue to do that transfer and work for them. I must say, I got to see what's going on. So this is general education only. some stuff might not apply to yours. So I'm not sure. I can't say whether you can work or not because I haven't reviewed your RFE or your case. But generally, you could work once the case is submitted for the transfer.
Okay. Thank you so much. I think it's the same person because they sound the same questions. But thank you so much, John, for taking that up. And now I have another question, and that is if you could tell us, one of the most frequent RFEs, which is related to specialty occupation requirement, and what key evidence should be included, to successfully respond to such an RFE.
Sure. I mean, it's a little bit of the person's background, their degree, maybe their transcripts too, to show what they studied. It goes into what the job is, and a really good description, a paragraph of like what the job entails, what is required, and sometimes you got to jump through more hoops for to explain it. There's government website, the OOH website, that breaks down what this job entails and whether it needs a degree and stuff. Using language from there is key, and sometimes having expert letters if the job is really kind of a vague job. Having an expert opinion, there's professors and stuff like that that'll write letters saying, yeah, this job based on this transcript and what your requirement is a specialty occupation. They describe it. That's something that could be obtained, but it just requires prep because you don't want to. If you think there's worries, you want to get started out soon because preparing all the paperwork for this could take weeks and weeks. And if you get an RFE, there's time limits on when you can respond to RFE. So you want to have a running start on this stuff. You want to know who you want to hire, who's acceptable to write this letter. So it's stuff that, again, it goes to being proactive to be able to prep for it. Sometimes, the law firms, there's cost to this because extra legal work, there's extra cost for this and that person, fees here, fees there. It's sometimes they might say, okay, we may be good as it is. Let's see if they push back, then we'll spend the time and money to try to develop a response. So sometimes you just do what basically will get it done 50% of the time or more, and you'll save the extra work needed for that. We don't like doing that at our office. We always require to do everything up front, even if it's like extra. But a lot of firms you work for, especially ones we don't do a million cases. Most of the H-1B filers are companies that might do thousands of these, so you can't spend the time individually to review all these and do all the proactive kind of stuff. So a lot of their game plan strategy is, okay, we'll file it. If there's pushback, then we'll deal with it. We'll have time the RFE. But our office, we don't like to wait for pushback. We try to be more proactive because we intentionally keep our caseload lower to do that extra work. It's just one of those versus like about like one of those things that we could do, but bigger firms that usually handle a lot of H-1Bs can't.
Well, thank you so much for taking that up, John. I have another question. If you could tell us, how should an employer handle an RFE which questions the beneficiary's qualifications, such as, a degree of equivalency or relevance of education to the job role?
So, the lawyer should get a copy of the RFE, but if they don't, immediately talk with the lawyer to review what specifically was problematic in the request for evidence RFE. And then, go back to the employee about his qualifications, see how he can be bolstered to show what it is, and then just rework and re-explain the job requirement, get expert letters, go on the government websites to show what it is, show that in the history of this field and our other employees, they have the same situation. Other employees that are U.S. employees in the same, doing what this person is doing, they also have the same job requirements and background. So this is typical of what we do. You kind of just dig in to document and explain everything that's there. This is typical and is expected in the industry. And again, you get industry letters, expert letters as well. Sometimes there'll be websites that talk about this, trade publications that talk about this stuff too. You kind of got to dig in deep to see how you could answer those questions.
Right, right. Thank you so much. And Control, now if you could display some of our questions from our Facebook groups or YouTube, maybe. But thank you, John, for taking that up so far. Also, meanwhile, if you can also tell us if an RFE requests additional proof, regarding the employer-employee relationship. So, what kind of documentation should be submitted to strengthen the case?
Yeah, this is a tough one when they get you on this, but essentially they want to see that the person who's an employee is actually an employee, means they can be fired and if at will, So if they're not really an employee, they're really like the owner of the company, they can't be fired. That's problematic. So you want to have systems in place, HR documents that say one of the terms are a contract with this person that says you could be fired based on cause and everything. Maybe have a board of directors that have control over this person, their position. Because, for example, they might be the president of the company. They'll say, well, they're at the top of the company. Who's going to fire them? But there's a board of directors that exists that can make a decision as directors to do that. So there are ways to do that. And the new policy by USCIS that came by administration kind of opened it up to say, it's still doable too. This person gets payroll. It's just it's a real job they're doing. They're not doing like the actual work, because they don't want people who are just are rich and kind of like own a company to say, oh, I'm working here, but they're not really. They have to really show to like what is the job they're doing that day-to-day basis. It's not like being a secretary kind of work, but at the same time, it's not just hanging out collecting checks and making money. What work are you doing that's related to your education? So they're going to be looking deep into these, but my guess is a lot more people are going to be filing this because they opened it up last year. And then this issue is going to come up more and more in this season, this year.
Yes, more explaining to do, and yeah, there will be more scrutiny for sure. So,
This one,
yes,
once you want to,
control.
if there's a
Yeah.
sense that there might be employer issue, you want to like proactively like prep everything ahead of time so that you're consistent from the beginning of what you're saying. You don't have to like clean that stuff up later. You want to make sure
Mhm.
everything is all your ducks in a row before you file that kind of case.
Interesting. Thank you so much, John. Now, control, if you could display some of our questions, please, from Facebook groups. So, this is from an anonymous participant asking, my first H-1B stamping was outside India. I'm within 12 months of my last H-1B visa expiry. I never had an H-1B stamping done in India. Am I eligible for Dropbox in India?
So one thing about the Dropbox situation that I'll just say is like there's word that they're changing everything with regard to interview waivers and Dropbox and stuff like that. So anything I say right now within an hour might be different, or it already is different. So you kind of just leave it up to them. You file the case, and then you see whether they'll say they want an interview or not. But everything's changing so rapidly with visa processing that I'm hesitant to even give an answer to that one right now. We're seeing like all sorts of different changes, particularly interview waivers, not required to go in person. That's changing.
Mhm, mhm, mhm. Well, thank you. Thank you, John, for taking that. Now, this next one is from Mohit. Hi, all. I find myself in a strange situation. I got laid off today. The company refused to sponsor my visa in November. I have been trying to switch before the lottery deadline, but have been unsuccessful so far. I have 5 months to look for a new role. This would have been my last lottery attempt. My STEM OPT ends in January 2026. What are my options? And is enrolling for a day one CPT course worth it? Will employers whom I interview with willing to bring me on just on my day one CPT? Any guidance is appreciated.
Okay, so first off, on the STEM OPT, you have a limited amount of time where you can be unemployed, so you have to make sure you don't fill that up. How much is it? It's like I think on I can't remember the exact numbers. On regular OPT, you get 90 days plus extra 20 days for STEM OPT. I can't remember exactly, but make sure you don't use up that time. Now, the problem with STEM 1 OPT is it's not per se a problem, but first of all, you have to go back to school. So you have to start a new school program, and so that's new F1.
Mhm,
There's a lot of fraud and abuse that potentially happens in day one CPT. A lot of people use it, no problem, but especially the Trump administration, you got to be kind of cautious. Make sure it's a legitimate program. If you go to that course, that school, you go to school as required. There's tests, there's exams, whatever the school requires. You pay the fee. It's not just a front where they collect money, you don't show up, and just give you work authorization this way. So there's that risk that exists with first day CPT. But with your question, will employers who interview with willing to bring me on? That's an employer. That's whatever the employer is. That's their decision. I don't have any power or knowledge of what they want to do. So if you could tell them that it's up to them. You got to explain that this is a job authorization. But it's really just it's kind of like, will they hire you? Let's put aside, let's say you're a U.S. citizen. I don't know if they're hiring you now. So it depends on how much they want you and how needed you are.
mhm. Well, thank you, Mohit, for your question, and also John for taking that up. So let's go on to our next question. This is from an anonymous member. I'm seeking assistance from anyone with experience in this matter. I'm currently in the process of changing my J1 visa to H1B status within the US without returning to my home country. I recently got married, and my home country may be on a travel ban list. My question is, if I obtain the H-1B visa, will the ban impact my wife's ability to secure an H-4 visa, considering I do not plan to travel back home? Can the ban affect her H-4 visa status if I have an active H-1B?
So this question about the ban is something I get all day, every day for the last several weeks. There is no at this time recording. There is no ban. There's just rumors and newspapers and stuff like that. So unable to
Okay.
give legal guidance on something that's not law. I'll just be making things up. So it's illegal for me to do that. And there's a lot of clickbait online of people talking about this because it gets a lot of attention. But there is nothing written down that's this. So I can't speak to hypothetical. Hopefully the ban is applied to you, but we don't know if there is a ban, what it would entail. If there's exceptions to it, there's loopholes to it, or what. Now, if you do change from J1 to H1B, you're even if you don't leave, your spouse, generally speaking, let's say they're German, a country that's probably not going to get a ban. Your spouse, even though you didn't get an H-1B visa yourself, just status in the U.S., your spouse could potentially apply for the H-4 and come. You don't need to have the visa yourself; just the status is fine. But with regard to bans, it's impossible for me to answer. Potentially, if you're married, without returning to my wait, say I currently in the process of changing. I recently got married in my home country, maybe on travel. So, how did you get married? So, if you haven't left for your home country, or maybe you left the J visa, came back, but you can get the visa. I don't know. But if you're married lawfully, you saw each other, it wasn't like an absentee wedding kind of thing. Maybe if you haven't changed, if you get the J1 as soon as possible, maybe too late for them to come as soon as possible. That's the only other thing I could say. But there's no official ban yet. So I'm going to go do a Google search right now. Let's see a travel ban if the news popped up. But there's nothing I can answer that. Even if it did come out, just read it, so I can't answer that. But travel ban trends. Okay, so it's just rumors right now. There's no official travel ban this time.
All right. That's interesting. Thank you so much, John, for that clarification. Because I
You're
think
welcome.
there are folks, who have been wondering what if a travel ban is imposed, and especially if it's their country on that list. So thank you, John. And now, if we can go on to our next question. This one is saying, hi everyone. I had my H-1B visa interview in the US consulate in Toronto on January 7th, 2025 at 9 a.m. Okay. The officer approved my visa, took my passport, and gave me the Know Your Rights pamphlet. However, my CEAC status changed to refused on the same day. Since then, the status keeps getting updated every Monday, but it still says refused. With only the date changing, no emails or additional document requests so far. Has anyone experienced this before? And how long did it take for your status to change to issued? Should I reach out to the consulate, or is it just a normal delay?
So this is like the horrible situation people get involved. Refused doesn't mean denied. It means they're doing additional research, review, and the like. And it comes a black hole many times where it just gets stuck. It's hard contacting the embassy in Toronto. I don't know if there's even a way to email them or contact them, and if you do, they'll leave an answer. But it's just, if you've been pending for 2 months now, over 2 months, yeah, contact them. Say, is there any documents needed or stuff? It's best to consult with an attorney to review what happened. There may be confusion about one of your documents that we could notice and be like, okay, this is the issue. Let's proactively contact them, or contact the senator, or the employer contacts the local senator to say, hey, this document didn't make sense, but we have clarification. Maybe that'll help do the homework for the embassy to solve it if that's the issue. But we don't know what country you're originally from, what background issues you have. There could be other things that we don't know about that are problematic here. So it could be just normal. It could be there's major problems. We just don't know anything about your background. But the fact that the date keeps changing on it means they're continuously working on it in some fashion. That every time they touch the case, they update it on the CEAC website. But there's no timeline for administrative processing when you get these refusals. It's called administrative processing refusal. You just want to try to solve the issue. But if you're like from a country like from Iran or something like that, these things happen all the time, and there's like 6 months, 12 months, 2 years of waiting because it's national security review. Those are open ended. Hopefully, it's just a document issue.
All right. All right. So this is the last one from our Facebook
Uh,
group. My
Actually,
first
we
H-1B
went over
stamp.
this one. Was there another one? This was
Yeah,
about
we
the
already did this.
John
Yeah.
Fox. We did this one as well. So, if
So
there are
we.
no other questions, yeah, the main thing is to prepare for the visa process. I mean, it's hard to prepare for anything because everything's going to be changing and delays are going to be happening. The main thing is have your documents ready and focusing on just filling out the paperwork correctly. So, most people watching this are probably not the employer, they're the employee. When you fill out your form DS-160, which is your background, make sure it's full,
Mhm.
proper. Don't have your travel agent do it. Don't have your cousin do it whose English is better, something like that, because they're not going to pay attention to answer questions properly. If you've been married before, list your spouse. If you have children, stepchildren, list all of them. excuse me, you don't want to come back later and say, oh, you didn't list this child, you're lying to us in some fashion, or you previously applied for his tourist visa, you're denied, you didn't tell us this time. Just make sure everything is properly done. And one thing about this Form DS-160 is once you submit it, you can't access it again. So before submitting, take screenshots of every page so you have record. So if a lawyer in the future needs to say, hey, what did you say in this application? You have copies of it. So a lot of times people come to us, they have no copies, almost every time, because when they don't have a lawyer, they don't save copies. So we have to make a request from the government for a copy of it, which they could not give, or it might take 6 months to get, but it's too much delay. We can't use that. So having the paperwork already ahead of time, it becomes really helpful for future attorneys to be able to see what's going on with your case.
Yes, absolutely. And I think it's always best to stay prepared and, avoid any sort of, misrepresentation. Say
Yeah.
all the information that is required. And thank you so much, John, for that, great session. Short, sweet, informative. And, well, maybe before we leave, if you would like to give out a couple of tips, maybe in the best way to respond to RFEs, maybe just
I
generally.
appreciate that. Yeah, one thing is just reading the RFE well. A lot of times people really get worked up, and then when we come to us, we read the RFE with them, and it's like, oh, it's an easy thing. They just want to copy your passport bio thing page. But like just the idea in RFE just got them so worried and heck that they didn't even read the whole thing properly. Mailing it to the right place, the right address, being mindful of the deadlines, and just keeping like addresses updated if needed. It's really more the basic stuff. The harder stuff, inevitably the lawyer sits and works on it and gets it done. But the mistakes that happen a lot of times are things you wouldn't expect. For example, people doing change of status from a J1 or F1 to H1B, they realize they have some sort of document issues that even though the H1B is good, some of the background paperwork is missing that's problematic or is not timely filed. So, like having pay stubs to show they maintain status, for example, they want to show like, okay, you're working as an OPT, now you got H1B, did you maintain it? So they might say, give us pay stubs. So keep all your pay stubs when you're on F1 OPT, a student visa working, to show that you're consistently working. You didn't have gaps, for example. So the documentation is the key. Keep everything you can. Just keep a file on Google, a copy of everything, scan it, take a photo of it, clear photos. A lot of times people take photos. They just take a piece of it, their hands in the middle of the page. For corners, no shadows, something like a print, and an officer of USCIS can read it properly. Documentation is what we do. It's all about paperwork. So you got to just keep good records of everything. And whenever you get a lawyer, it's easier for them to get the job. And it comes cheaper too, because when people come to us and are missing documents, we got to do extra work and the price goes double. But if you have everything for us, we could read it. It's much faster and the price goes down. So it really saves you a lot.
Right. Right. Thank you so much, John, for those awesome tips, I would say. So
Thank you.
thank you for joining us today. It was wonderful having you, very informative, and it's always a pleasure having you on our show. So thank you
So
once
God
again.
bless you. I appreciate you having me on.
All right. So have a happy H-1B season, I would say, and I hope to see you soon once again. So hopefully we can catch up soon. Bye
We'll love it.
bye.
Thank you so much. Bye, everybody.
So, friends, you can also contact attorney John Q. Khosravi, and you can do so by calling him up on his number 818-934-1561, or mail him at info@jqqlaw.com, and go visit www.jqqlaw.com to get to know more about John Khosravi. And also, you can email me or call me or WhatsApp me on my number. And my phone number is 408-335-6444. And email me at nipa@staffingly.com. So thank you once again, friends. Don't forget to subscribe to our channel, hit that bell icon. And our handle is Immigration Talk Show. We are not only on YouTube, but also on LinkedIn, Facebook, X, and also on Instagram. So check us out, follow us, and connect with us. Thank you. And yes, stay tuned on Immigration Talk Show for more